Let's talk about what this is not. This is not a contempt hearing. Judge Miller is trying to make this a contempt hearing to where Your Honor would decide whether I'm in contempt of his gag order. That is not proper, and that is not proper according to the Nevada Code of Judicial Conduct 2.1, as Your Honor is only permitted to rule on things before Your Honor and not to interfere in other cases, which would include the municipal court case. If Your Honor finds that this gag order does not violate the First Amendment and upholds this gag order, Judge Miller can certainly find me in contempt. I would hope he would give me a hearing. I would ask for a hearing because I have explanations for everything that he's presented. But this is not a contempt hearing, and frankly, Your Honor, I think it's improper for them to try to make it so. I'm here exercising a constitutional right, and for them to try to threaten me with coming here and being jailed for specifically 25 days, it's wrong. It is just wrong. It's intimidation, and it is plain wrong. And I hope Your Honor will not turn this into a contempt hearing, and that you'll simply hear my plea for my First Amendment rights to be reinstated according to the petition of the writ. Let's talk about the facts of this case. I was dismayed when I read the response. I was disheartened to see that Craig Anderson is the attorney that Judge Miller hired to represent him here. Why? This case has a companion civil case in the federal court. Guess who that attorney is for the city of Boulder City? Craig Anderson. Now, the city of Boulder City and the judge in my criminal case have a common attorney, which makes it impossible to go around any ex parte rules. Judges, unlike attorneys, are under a heightened rule to where anybody under their control and their actions are attributed to the judge. So, if everything is attributed to everybody under his control, that means that by law, if the city attorney is talking to their own counsel, Craig Anderson, about the facts of this case, they are talking to Judge Miller. It's ex parte. And there's a litany of other rules of professional conduct for judges that come into play here. There's 6 of them, all because Judge Miller decided to hire Craig Anderson. The only declaration they attached, Your Honor, was the declaration of City Attorney Steve Morris. Why in the heck are they working together on this? The trial in the criminal case with my client is not until May 23rd and 24th. So why is the city attorney specifically working together with Judge Morris against my client's attorney and my client? Not only that, but Judge Miller, in his response, adopted the exact facts of what allegedly happened with my client that's at issue in the criminal trial that the city alleged in their motion for summary judgment. Page 3 of my reply. Highly prejudicial and damning facts to where Judge Miller is declaring my client guilty in a case that he is overseeing. This is ridiculous. This is so wrong. And adopting verbatim, the facts from the motion for summary judgment before trial? My client cannot get a fair trial here because of Judge Miller and because of Craig Anderson.
Well,
he's guilty.
Well, Mr. Stubbs, those issues are not before the court. The issues before the court are your First Amendment petition.
You're right, Your Honor. However, the point is Judge Miller has thrown in the wastebasket all of the canons of judicial conduct and the First Amendment in this case. He's thrown that in the wastebasket, and it's proven by his response and how he chose to respond, declaring my client guilty before trial. Those are the ethics of this man, who is a man that I used to look up to. I used to look up to him. He was my youth leader in church, for heaven's sake. As a 12-year-old kid, we went to the lake together. We went to the temple together. We went all over the place. And this is what he does? The facts of this case are a First Amendment case where my client was legally walking in a crosswalk to protest an enforcement event by multiple law enforcement. He walked legally, and it made John Glenn, a sergeant, mad, and so John Glenn falsely arrested him, and we are alleging that he falsified evidence, and there is extreme corruption in this case. And the city charged him with some crimes. A surveillance video came out, and as soon as the surveillance video came out and showed that all of the cars yielded to my client, because the charge was stepping out in the crosswalk in a manner where it's impossible to yield. As soon as that came out and showed and proved that everybody yielded, it was dropped, dismissed. There was still the statute because it was dismissed pursuant to statute, so the statute of limitations applied. And my client sent all these videos to experts and found discrepancies that could not be ignored. And because of that, in May of 2017, we filed a federal lawsuit. Then they hired Craig Anderson. Then they refiled charges and they upped the ante. They added an obstruction charge specifically for walking in the crosswalk during the enforcement activity. Now that's important, Your Honor, because it goes to the heart of my speech that Judge Miller found so offensive. Because I made a Facebook post that simply showed the press release, a public record, from the Boulder City Police Department instructing everybody to walk in the crosswalk, and then showed a cropped, the crop for the exact charge in the complaint for obstruction that charged him simply walking in the crosswalk during the enforcement event. And I said the words, Boulder City City Attorney Steve Morris does not care about the First Amendment. That is what happened at Facebook. That is what happened. And that is what set off Judge Miller. And that was the crux of this gag order. And unfortunately, Your Honor, Judge Miller and Steve Morris, they have another conflict, as Steve Morris is Judge Miller's LDS Stake President. Now, I set this out in my petition, and I would note that none of it has been challenged. Not one word of it has been challenged of the positions of Judge Miller versus his LDS Stake President, Steve Morris. Because under Mormon doctrine, Steve Morris has authority to receive prophecy and revelation for everybody within his stake, including all of Boulder City and including Judge Miller. Now, I took offense to that, and I was planning on speaking the next Tuesday in the City Council, both about this issue here that I've just addressed, and Steve Morris continuing to violate the First Amendment by continuing to move forward with the charge, and also the fact that there's a conflict of interest in that relationship, to where the prosecutor is the spiritual judge in Israel. That's the quote, spiritual judge in Israel of Judge Miller. You know, maybe that doesn't make any difference with a law argument. Maybe it doesn't make a difference with a fact argument, but it certainly makes a difference with a moral argument. And how is it fair for anybody to face a moral argument where the person on the other side has moral and religious authority and the authority for prophecy and revelation over the judge? So I wanted to talk about that. But Judge Miller issued a gag order, a broad gag order that included both me and my client. And on Monday, he called me ex parte at my home, and he threatened me, and he said that I had to shut up my client's father, Ainsworth Hunt.
Objection, Your Honor. I know I'm not the attorney here, but there is nothing we've been presented to show anything about this conversation. Steve's a friend.
Well,
we've had many conversations over the years, and I object to the hearsay nature of this.
I understand.
That's improper.
I am going to listen.
Okay.
But I'm going to listen fully to both sides.
Of course. He threatened me. And he says, I guess I need to include Ainsworth Hunt in the gag order too. Phone records will show he called me. My wife was sitting next to me during the entire thing. It was an improper ex parte communication to where he threatened me. And I called his bluff. And I said, you better look at the Gentile case because I'm going to sue you. If you include Ainsworth Hunt in this, he's going to sue you. He even said, does he want me to recuse myself from the case? And I said, he doesn't think you should be a judge. But Judge Miller threatened me. He threatened me. And then, an hour and a half before, on Tuesday, an hour and a half before the hearing that I wanted to speak at, he issues his written order. Now, before that is this broad order. This very, very broad order, to where he threatened to attribute anything that Ainsworth said to myself, which would be improper. An hour and a half before the hearing, he sends out this gag order, which is less, but it's still not proper. But he accomplished everything he needed to because he protected his stake president. Now, under Mormon doctrine, and I cited to this in my petition, it is improper. An apostle to the Lord in the LDS Church, Dallin H. Oaks, said that it is improper to criticize a church official even when they are wrong. That is what Judge Miller took offense to. That is what happened here, and that is the sole purpose of this gag order. Judge Miller cannot stand the fact that I am criticizing his LDS Stake President. Mission accomplished. He was able to keep me an hour and a half before the hearing. It's not, I can't prepare anything in that time. And you know what? At that hearing before the Boulder City Council, Steve Morris got his permanent contract, and he broke a record for the amount of money that was paid for that permanent contract. My speech was suppressed. That is what happened, and that is what this is all about. There is no likelihood whatsoever under Levine or under Gentile that what I say will have any influence on Judge Miller, and I would even say in the courtroom. Why? Because Judge Miller has already made up his mind. How do we know? He told you in his response what the facts of the case are before trial. He's going to listen to his stake president. He has already made up his mind, and he put it in writing that he is adopting the facts before trial that the city put in their civil motion for summary judgment. Therefore, there is zero likelihood that anybody can have a fair trial in front of Judge Miller, and anybody can change his mind. Much less a substantial likelihood that my simple Facebook page will prejudice the proceedings. There is none. Judge Miller tries to bring in the fact that there's a jury in the civil case and tries to bring that in. That is improper for a number of reasons. Judge Miller has a very limited jurisdiction. It's a municipal court. He has a jurisdiction for the municipality and what is before him in that municipality. It is both a violation of the second canon for him to usurp the federal case or the facts of the federal case or interfere in any way with that federal case. It is against his judicial canons for him to try to usurp that and say, oh, there's a jury in another case, so I'm going to issue a gag order in this case where there's no jury. That is improper and it is unethical. It's wrong. Now, Judge Miller is also right now a public official. He is a public official himself, and he is also running for re-election. That opens up the judicial canons of 4, dealing with when he is a candidate running for office. He cannot say anything or rule on anything that might affect any case that's not before him. You tell me how this doesn't affect the civil case if he's specifically saying that he's doing this because of the civil case. He's thrown his ethical canons in the garbage. Now he's putting the lighter fluid on it, and he lit a match. Completely improper. 100% and completely improper. His jurisdiction is set out in NRS 5.050. And that jurisdiction deals specifically with the municipality and the municipality only. Inside Boulder City, not in this federal court over here. That's all he has the power to do as a municipal court judge. That's it. But he tries to usurp other authority. This is preposterous. I'm well within my rights and my expression rights under the First Amendment. I am well within, with no jury, in criticizing public officials that were about to be appointed permanently. That the matter was before the city council. But Judge Miller wants to protect his stake president because as Mormons, we're ordered by our apostles not to criticize our leaders, even if they're wrong. And Stephen Morris and Judge Miller interfering in this is wrong. Them being the same, having the same attorney and being together in this is wrong. Steve Morris making a declaration and working with Judge Miller on this action is wrong.
So the facts that are included in the motion that we drafted were put by me, but they are John Hunt's facts. They are not an adopted, slanted set of facts. We carefully took the facts from his deposition and put them in that motion. So that's all they are. They were just to give the court context. There is certainly a serious threat here. The fundamental interest in ensuring integrity of the judicial system is at play here.
Can I ask you something?
Absolutely.
Looking at that, I mean, the activity poses a clear present danger. Now you're saying that it is, I think it prejudiced the community. I can't remember the word that you used, but I mean, why do we care what the community says? It really, Judge Miller is the one to decide the case. I mean, and unfortunately, we judges, we upset, I always say we upset 50% of the people all the time in our courtroom, but I guess if the community is upset, well, they're upset, and the issue is whether or not it causes an issue with, prejudices the judge. And I have to say the Scarfo case, I'm just reading it now for the first time, but that was kind of my thinking, is that, hey, we have to think above that. So why do we care what the community thinks?
And I think you'd go to Levine for that, is that the community has a perception of how government officials, prosecutors and defendants should conduct themselves, and is that there is a relevant community issue that the community has to feel secure in what's going on in their courts. Calling people idiots, saying a prosecutor doesn't understand the Constitution. It doesn't serve any purpose. There are better ways in the context of a specific case. And that's what Judge Sneed was saying here, was that respect for the profession. It's important here.
I will be honest with you, when I read that last sentence, I was concerned about it being overly broad. For example, it prohibits all counsel from engaging in extrajudicial communications that in any way disparage or otherwise comment on opposing counsel relative to this case. I mean, if you take it to the extreme, Mr. Stubbs could go home to his wife and disparage counsel all he wants, Mr. Booker or Mr. Morris, and he could be in violation of this gag order.
Not up to date on Mormon church hierarchy or how these things are operating, or personal allegations or personal. All that I can tell you is we were retained to represent the city of Boulder City. We used his client's facts in our motion, to be fair. And as you know, in a summary judgment motion, the facts that you provide are the ones most favorable to the non-moving party. And all we did was cut just a brief section out of that was supported by his client's deposition.
Stubbs?
Judge Miller might as well be singing Cher right now. If I could turn back time, if I could find a way, because that's exactly what he's doing with Levine. A 1985 case. If he could turn back time to Levine, maybe it would be okay. I still say it's not. And Craig Anderson is not fulfilling his responsibility for candor to this court. Let me read you the facts that were adopted by Judge Miller in his response. On June 8, 2016, several Nevada law enforcement agencies were conducting a crosswalk enforcement activity where officers cited drivers who failed to yield to a decoy pedestrian in the crosswalk. Guess what? My client never said that. Okay. During the activity, Hunt blew through the crosswalk, almost struck the decoy, and subsequently received a traffic citation. Where in the world has my client ever said that they, quote, blew through the crosswalk, almost struck a decoy? He did say that he received a traffic citation. Hunt, after thinking about the disgusting activity, he did call it disgusting, returned to the crosswalk with the intent of walking back and forth in the crosswalk until infinity. He said that. Upon reaching the crosswalk about 40 minutes after receiving the citation, Hunt, without looking for traffic, darted out into the crosswalk. He never said that. Forcing vehicles to abruptly stop to avoid hitting him. That's a direct quote from the police report. A direct quote. After Hunt's third trip across the crosswalk, Sergeant Glenn, who had no knowledge of Hunt's prior traffic stop, decided to contact Hunt to determine whether he was intentionally interfering with traffic, i.e. a crime. Did my client say that? No. These are direct quotes from the police report that have been adopted by the judge. The police report. I.e. a crime? Do you think my client would be accusing himself of a crime? Ridiculous. Ridiculous. Even more ridiculous is the next. Or whether he was a danger to himself or others, i.e. mentally ill, intoxicated, or on drugs. Judge Miller, adopting the police report and the deposition of the police officer, not my client, he adopted those facts. Verbatim what was put in the motion for summary judgment. This was not fair to my client. It was not right. And Judge Miller adopted them. Do you think my client thinks he's mentally ill, on drugs, or intoxicated? Do you think my client's accusing himself of a crime? That's what it says. We could go on, but more than half of this is quoted directly from the police report adopted by Judge Miller. It's just baloney, what Mr. Anderson said. It's not candor to the court. It is not true. And he drafted it. Craig Anderson was also not showing much candor to the court because not only did Morris appear in the December hearing, he argued the case. And guess what he did? He didn't argue the facts. He didn't argue the law. He argued the morals. We had experts dealing with how everything was not authentic. We had all those things. We had everything. They didn't offer one expert. He declared it a conspiracy theory and then went to his the person that is subject to him religiously, and pointed to Mr. Stubbs and says, what Mr. Stubbs does offends me because he's disparaging our great police department. Now, is that a lawyer talking? Or is that his ecclesiastic leader talking? Because he argued the case. He also attended the First Amendment hearing. Interestingly, he doesn't do anything else. Gary Booker does practically everything, and I'm not aware of one instance to where Steve Morris has attended or argued anything else. But when there's finances on the line dealing with the civil suit, and when he can use his influence as an ecclesiastic leader, he sure shows up. Now, they say, not good for the community to see this. Clearly from Gentile, that is not true. Gentile says the exact opposite, and I'm not going to repeat myself. But Judge Miller says this is not good for the community to see this. And the United States Supreme Court in Gentile says, calling into question the motives of a prosecutor is exactly what we need and an important check on our government. Calling out allegations of corruption in police departments is exactly what we need, an important check on the government. Judge Miller's wording directly contradicts the United States Supreme Court. And again, there's no jury here. It's just Judge Miller. Him trying to control the speech into the community, that's why he called me on that Monday and threatened me to shut up my client's father, or else he would include him in the gag order. Your Honor, they also say that I'm saying that Steve Morris doesn't understand the First Amendment. I've never said that. I've said he doesn't care about it. I'm questioning his integrity. And he's a prosecutor, and he's a public official. And that's important. And any other prosecutor that does that, I do that too. Because they should not be violating the First Amendment rights of the citizens. And I stand by that. And I never called him an idiot. I specifically said, after the fact, the gag order prohibits me from calling him an idiot, so I won't. Those are my exact words. You can watch the YouTube video. It's attached. I never called him an idiot. I specifically didn't. I wanted to. I probably would have if there wasn't a gag order, but I didn't. Fact is, he's way out of bounds here. Way out of bounds. And relying on Gentile, it is my duty to call it out. In the small community that we're in, with my Facebook and with my YouTube. That's all I'm doing. All I'm doing. But that's not what he was trying to do. His own words. It is not good for the community to see this. He is specifically trying to preempt speech to the public, criticizing his LDS Stake President, the city attorney, Steve Morris. He admitted it. That's what he's trying to do here, and that's what's wrong.